Oops, don't forget your normal day-to-day activities. There are many parts to the statutory definition of disability that need to be fulfilled before one can be deemed a disabled person, none less so than the effects of the impairment, physical and or mental, on one's normal day-to-day activities. Remember, we are concerned with a statutory definition, under the Equality Act 2010, the Act, therefore focusing solely on the impairment is generally insufficient. There are exceptions. This means, generally, if one proves that they have an impairment but fail to show the substantial, more than minor or trivial, and long term, that has lasted at least 12 months, where the total period for which it lasts, from the time of the first onset, is likely to be at least 12 months, or that is likely to last for the rest of the life of the person affected. Adverse effects of the impairment on their ability to carry out normal day-to-day activities, they will not be deemed a disabled person under the Act. In the recent sitting in Edinburgh case of Francis Matombo Mpenia v Angered Staffing Solutions Limited, the claimant suffered from essential hypertension impairment, and, therefore, claimed to be a disabled person under the Act. There was no dispute that he suffered from the alleged impairment, but he failed to adduce evidence of its adverse effect on his normal day-to-day activities, let alone whether such were substantial and long-term. Therefore, he failed to discharge the burden of proof that he was a disabled person as defined under the Act. Notwithstanding the above, however, another interesting point was in issue, which ought to be of interest to employers and HR practitioners. The claimant had completed the respondent's recruitment process. An application form formed part of this process on which he indicated that he did not consider himself to have any form of disability. After he was appointed, he refused to work on some, not all, night shifts due, generally, to his health condition. The question is, was this, due to the claimant's health condition, enough for the respondent to have had constructive knowledge that he was a disabled person under the Act? No, said the ET, to which the ET agreed. The ET took the view that the claimant's reference to his health condition was something that should have put the respondent on notice to make further enquiries, but it did not go so far as to say that the respondent had failed to make such further enquiries. Lessons to be learned. Firstly, it is important to note that reference to an impairment alone is, generally, insufficient to prove that one is a disabled person under the Equality Act 2010. Secondly, even though an applicant indicates that he is not a disabled person or do not believe themselves to be disabled, is not conclusive and or determinative of the issue. For example, they may not know. Finally, unlike in Matombo Mpenia, an employer could be found to have constructive knowledge of its employee's disability, even where initially that employee had indicated to the contrary, if there are sufficient signs in place to indicate such and the employer fails to make such further enquiries accordingly. Ryan Clement is a practicing barrister, specializing in, amongst other things, employment law.